the case Neetu Singh and others versus Telegram. Going to the facts of the case, the plaintiff, number one, that is Ms. Neetu Singh, who is an author of various books which are used for competitive exams like UPSC, CDS, etc. So there are two plaintiffs here, basically Ms. Neetu Singh and KD Campus Private Limited, which is an education institution started by Ms. Neetu Singh. They had filed the present suit seeking permanent injunction restraining infringement of copyright in respect of unauthorized dissemination of the plaintiff's video, lectures, books, etc., which was happening via the app Telegram. So Telegram basically is a messaging platform capable of being downloaded on various phones, tablets, computers, and other gadgets, and which enables the transmission of audio files, text files, videos, images, documents, etc. So the plaintiff noted that a lot of private channels had come up on the app, which was supposedly making the plaintiff's lecture videos available and accessible for students at a very highly discounted price. The plaintiff also found that the books of the plaintiffs were being circulated in PDF formats for easy download for everyone to use. The plaintiff reported this abuse to Telegram, and upon the receipt of the said notice, few channels were taken down by Telegram, but some infringing channels kept cropping up every day with minute changes in the name of the channels which were previously used. So the issue was the plaintiff filed a present suit alleging that the plaintiff's copyrighted work, that is the lectures, the books, the PDFs, and the videos, or all course material, was being disseminated unauthorizedly through the various Telegram channels. So the plaintiff's argument was that as per the privacy policy of Telegram, if there is any violation of law, Telegram is liable to take down these channels and also disclose the information relating to the persons who are running the said channels. Further, while the channels that were reported to Telegram were brought down and taken down, new channels kept cropping up with some different suffix or prefix by making small modifications to the names of the channels, and they continue to be created. Accordingly, plaintiff requested for the identity of the person who was disseminating this infringing material to be disclosed to them so that they can avail all their remedies against the said person. Now, the defense arguments was that the interim arrangement between Telegram and plaintiff, that is where Telegram had already taken down the infringing channels, was enough to protect the interest of the plaintiff. Also, as for the privacy policy of Telegram, until and unless a person is expected to be a terror suspect, the disclosure of the subscriber information could not be made. The defendants also relied on the guidelines stated in the Information Technology Intermediary Guidelines and Digital Media Ethics, which primarily requires the intermediary to only take down, remove, or disable access to the unlawful information. The defendant also placed reliance on the fact that the servers of Telegram are based in Singapore and were highly encrypted. Accordingly, decryption of the data would not be permissible except as per the laws of Singapore. Now, the court here decided in favor of the plaintiffs and directed Telegram to disclose the details of all infringing channels and their owners to be mentioned to the plaintiff. So the plaintiff had submitted a list of channels which were infringing her material on Telegram and had submitted the same to the court. So the court decided that the defendants have to give the information and disclose the information of the owners of those particular channels, and along with any other channels that they may come across who are infringing the plaintiff's copyrighted material. Now, the important aspect here that we need to concentrate is when Telegram claimed that since their servers are based out of Singapore, they do not have to disclose the group owners' information. The court stated that merely because Telegram chooses to locate its server in Singapore, the same cannot result in the plaintiffs being left completely remedialess against the actual infringers, especially in order to claim damages and avail of legal remedies. So basically, the court stated that just because they choose to place their servers outside of India, they cannot claim that they're not liable under the laws of India, because they have a good client base in India. They have been gaining a lot of premium services from a lot of users in India. Hence, the courts of India are competent enough to pass decisions against them and direct them orders to ensure and protect the rights of a plaintiff. And also the court stated that the dynamic evolution of law is essential to ensure appropriate remedies in case of violation of copyright and other IP laws.